Welcome to Law and Society. Today we're going to talk about the Supreme Court's ruling that it would accept the appeal of presidential immunity. So if you're new to my channel, please like and subscribe, and let's get into it. So the Supreme Court has opted to grant certiorari, meaning accept the appeal of the issue of whether there is presidential immunity or not. What Donald Trump asked the court to do was to stay the lower court, meaning the DC Circuit Appeals Court's ruling, until the case went through the ordinary course of appeals, meaning they were going to go to the full DC Circuit Court of Appeals en banc, and then they were going to appeal it to the Supreme Court. So the Supreme Court said no to that effectively, and said that we are going to take this request to deny stay as a writ of certiorari and grant that writ, meaning we will hear this case. So I'm going to read you the brief note that the order list that SCOTUS listed, and then I'll just give a few comments. So the application for a stay presented to the Chief Justice was referred to him by to the court. The special counsel's request to treat the stay-up application as a petition for a writ of certiorari is granted. That petition is granted limited to the following questions. So the Supreme Court gives us what it is looking at. What is the question at hand? What is the issue presented? The issue presented is whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Now, it's a heavy thing there. And the question is whether a former president enjoys presidential immunity. And then the Supreme Court goes on to say, to what extent, if there is presidential immunity, does it cover them from criminal prosecution in acts that are alleged to be official acts? And we know through the briefing schedule, through the briefs and all of the other court documents that Jack Smith has submitted, that shows how this is not an official act. An act that has been legislated and enacted by Congress as a crime cannot be an official act that falls within the outer perimeters or inner perimeters of the chief executive. So, without expressing a view on the merits, this court directs the Court of Appeals to continue withholding issuance of the mandate until the sending down of judgment of this court. So then it sets a schedule saying that the case will be heard on April 22nd. Petitioners' briefs on the merits and amicus briefs in support or in support of neither party are to be filed by March 19th. Respondents' briefs and amicus briefs in support of the respondent are to be filed by April 8th, and the reply of that should be filed before April 15th. So the case is set for oral arguments on April 22nd, 2024, the week of that. And then I suppose the court can take anywhere from, if it's an expedited schedule for them, 3 weeks is expedited, So we'll probably get to May to get the ruling. And then after that, at least another 40 days that goes to June and July. July is perhaps when, if the Supreme Court says that there's no presidential immunity from criminal prosecution for former POTUSes, only then the case moves forward in Judge Tanya Chutkan's court. If the Supreme Court rules that there is presidential immunity, residual presidential immunity of a former POTUS, and then also accepts that what he was doing were official acts, then it can rule that he does have presidential immunity from criminal prosecution, which would turn the rule of law on its head. I don't think that the Supreme Court would do that. I, however, think it's slightly problematic that the way that the Supreme Court has phrased the issue presented, whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. So alleged official acts will be something that they will be looking at, whether it fell within alleged official acts. And legislatively enacted laws that are crimes cannot be official acts of the executive. So, on that argument, I believe that Jack Smith will win. And this is going to be a case of first impression that's going to set whether or not former POTUSes have any sort of immunity. And then from this one goes to from criminal prosecution. So it's a pretty big deal. And I don't see the Supreme Court saying that, presidents have, former presidents have presidential immunity from criminal prosecution. I don't see that happening in a logical sense. But then again, this is the Supreme Court that is heavily conservative, and we don't really know how they're going to rule. So, Donald Trump's criminal trial in the DC case has been postponed at least to mid-May, then June, at least till June. It'll probably be June when we would see, if there's no presidential immunity, this case coming up for trial. So Donald Trump's delay tactics have been effective. The Supreme Court has decided to hear the immunity issue before letting the underlying trial go forward. In many ways, by not denying the stay and allowing the lower court's case to go forward, the Supreme Court has sort of stamped out the public interest in a speedy trial because they have effectively, with this order, ignored it. The whole month of March, there's only one date when there are filing deadlines. And then it goes into April, to the end of April. So I don't know how 50 days is expedited schedule. Maybe it was in the days of the horse and buggy, but we have moved to the era of airplanes and emails and all of that. And I hope that the Supreme Court catches up to that sooner rather than later. With that said, I will now patiently wait for all the briefs to come in and pay attention to some of the other matters that Donald Trump has entangled in. So if you've been here this whole time, thank you so much for being here. And please like and subscribe. I'll talk to you soon.